Michael Lewis and T. Bell and others.
Yes.
Please, my lords. I appear in this matter with Mr. Richard Viney, my own friend, Mr. Philip Moser QC, and Mr. David Lifton QC, here for the respondent.
Yes.
My lords, this claim arises out of an accident which took place in a field between the claimant and the first defendant farmer's vehicle. The judge found that the MIB would be liable to satisfy the judgment against the first defendant pursuant to 2 points. First point was the direct effect of Article 3 pursuant to Directive 2009-103. And the second point was the finding that the MIB was an emanation of the UK state.
Yes.
I need to take those 2 points in turn, and I'll deal with them in the same order as the judge. But first I need to go to the relevant legislation. So my plan is relevant legislation, direct effect, and then the results of that by way of the emanation of state. So I started the EU legislation. The relevant directive is at tab 8 of the FATA bundle, the supplementary bundle as it's called. Tab 8, Lord.
Yes. So this is the 2009 directive.
It is. Yeah. In tab 8, I can go straight to Article 3. The recitals don't really add anything much to the terms. So it's on page 301 of the bundle. And on page 301, Article 3, compulsory insurance of vehicles, each member state shall, subject to Article 5, take all appropriate measures to ensure that civil liability in respect of the use of vehicles normally based in its territory is covered by insurance. So in essence, we say member states must introduce a system to ensure that the use of vehicles is covered by insurance, i.e. to impose on drivers an obligation to insure. And then the second subparagraph of Article 3,
Yes.
the extent of the liability covered and the terms and conditions of cover shall be determined on the basis of the measures, that's the member state measures, referred to in the first paragraph. So what cover, it's unsurprising in a way, but what cover insurers are required to provide is to be found in national law, and national law must satisfy EU requirements. Because, of course, being a directive, it is binding as to the result to be achieved, but leaves to member states the choice of form and methods, Article 288 TFEU. And so, I think that that's all we need from Article 3 at this stage. Article 5 is worthy of note. Article 5 deals with some derogations, 2 classes of derogation. Derogation in respect to a particular legal person, on the one hand, or derogation in respect of a type of vehicle, on the other hand. 5.1 deals with certain natural legal persons, so a member state may derogate from Article 3, i.e. not impose the requirement of compulsory insurance in respect of certain natural legal persons. And we'll see in due course, the UK has derogated.
That's in relation to the Crown, isn't it?
It is, essentially, in the UK, in Section 144, we have done it in Section 144 of the Road Traffic Act. We have done it in relation to various Crown bodies, such as local authorities, fire authorities, and we'll see briefly as we pass through the English legislation.
Yeah.
I mean, that's what we have done, but of course, natural legal persons, public or private, the discretion is broader than that which we have exercised, but we have exercised in the way we have exercised it. And then a member state so derogating shall take the appropriate measures to ensure that compensation is paid in respect to any loss or injury caused in its territory and in the territory of other member states by vehicles belonging to such persons. So that could be a fund, could be covered by the relevant legal person, as I think it is, and my junior instructs me that is what we do in the UK, that if a local authority vehicle is not insured...
Well, it's self-insurance.
It is.
Self-insurance through with an obligation to effectively to provide an indemnity for the same amount as would have been provided if there had been compulsory road traffic insurance in place.
Yes, yes, my Lord. But of course, I mean, in a sense, that's the way we have done it. I mean, it would have been equally adequate to set up a fund for perhaps, I mean, one could imagine, I don't know whether it is the case, but in many continental law systems, the public service and everything to do with the public service is separate from the private. And so, for example, in general circumstances in France, when you sue a local authority, even on a contract, you have to go to the administrative court for that. And so it could be a fund, or it could be, as we have, a form of self-insurance.
But these derogations don't touch on the facts of the present case.
They don't attack, no, but that's just part of the context, the legislative context in which the Articles 3 and 10 occur. And so, over the page, it shall in particular designate an authority or body in the country where the loss or injury occurs, responsible for compensating injured parties in accordance with the laws of that state, in cases where Article 2A is not applicable. Communication to the Commission, publication of a list, and then 5.2, a member state may derogate from Article 3 in respect of certain types of vehicle. One might imagine there, possibly, vehicles used only for motorsport, possibly, if that's a relevant class of vehicle, or other classes of vehicle. One could think of other invalid carriages or other classes of vehicle. Certain vehicles having a special plate. The list of such type of vehicles shall be drawn up by the member state concerned and communicated to the other member states and to the Commission. Any member state so derogating shall ensure that the vehicles referred to in the first subparagraph are treated in the same way as vehicles for which the insurance obligation provided for in Article 3 has not been satisfied. So again, there must be in a sense, one sees from, as we come on to Article 10, vehicles for which the insurance obligation provided for in Article 3 has not been satisfied are put under the responsibility of a body. But here, one must treat them in the same way, and it seems that envisages, I mean, it could be the Article 10 body. It doesn't require it to be the Article 10 body, it could be a separate body. Although one notes in the next subparagraph, the guarantee fund of the member state in which the accident has taken place should then have a claim against the guarantee fund of the member state where the vehicle is normally based. So there's no, in some directives, one does have a statement saying that the member states may set up a range of bodies. We don't have that. Article 10 appears on its face to envisage one body, but would it be satisfied by a number of bodies? And we would suggest the answer to that would be yes. For example, and I should, well, perhaps before coming on to an example, I should just go to Article 10, but I note in passing...
I'm so sorry, before we go to Article 10, just for completeness while we're here, I wonder if I can just also draw your Lordship's attention to the second two paragraphs by the first hole punch on the left on this page, my learned friend read past.
So which two are those, Mr Mayor?
It shall communicate to the Commission the list of persons, top left, and the Commission shall publish that list. Just for completeness.
Yeah, I mean, this certainly in relation to types of vehicle appears to contemplate that the Commission, this is as it were a moving target, and the Commission is potentially looking into how effective this is as a form of derogation. But it doesn't concern us for present purposes anyway.
My Lord, no, it does not.
Yes. I mean, the underlying point which seems to emerge is that, yes, we have the facility to make derogations, but the underlying purpose is that there should be an effective system of insurance in place, as one would expect.
Yes.
And the member state must ensure that that is the case.
Lord, yes. But, I mean, that's obviously the overall objective.
Yes, but of course I know one also has to look at the precise way in
Well,
which it is done. And
Well,
that
indeed. That's the point, because I mean, one couldn't differ from that, and obviously there are certain statements about that's the overall intention when one looks at the motor insurance directives together. That's what they're trying to achieve.
yes.
Yeah. Right. Article 9 sets minimum amounts of compensation.
Yeah.
It's stated there 1 million. I think that's now, my junior instructs me that's now up to 1.2 million, but nothing turns on that. But that's you'll notice in the judgment. The judge said direct effect up to the minimum amount. And we don't, obviously, but that's different. That's not a point with which we take issue.
Yeah.
Article 10, each member state shall set up or authorise a body with the task of providing compensation, at least up to the limits of the insurance obligation, 9, for damage to property or personal injuries caused by an unidentified vehicle for which the insurance obligation, provided for in Article 3, has not been satisfied. So, the first paragraph shall be without prejudice to the right of the member state to regard compensation by the body as subsidiary or non-subsidiary. So it may be that if another insurer has potential responsibility, one thinks of the Holden case, there was just recently in the Supreme Court, a car being repaired in a garage.
Yeah.
Was it the garage insurer, the property insurer, or was it the motor insurer? And the Supreme Court.
I have cause to remember that case, Mr. Frankovich, because
Well, indeed.
you persuaded the Supreme Court to overturn us.
I don't mention it for that reason. Sorry, just the facts, because I find as a non-specialist in this field, keeping the facts in one's head is of all the different cases, the different.
Yes,
but it just struck me that one was an example
Indeed.
of that sort of situation.
Yeah.
And the right to make provision for settlement. But I don't think I need to read on. I think the words in there at the end, the insurance obligation provided for in Article 3 has not been satisfied. And that does demand a short pause, because of course the insurance obligation, Article 3, I mean, that operates at two levels, because there's the first level, which is between the EU and the member state, and that's the obligation. It's not disputed here that following Varuk, the obligation of the UK was to introduce a system of compulsory insurance for the use of vehicles as means of transport, including on private land. So that's what the UK was required to do. But there's a second level to insurance obligation, which arises in respect of these words at the end of the first paragraph of Article 10, for which the insurance obligation provided for Article 3 has not been satisfied. That, of course, requires analysis of national law, because under national law, member states must create an obligation on drivers to take out a policy of insurance. So the relevant obligation when speaking about not satisfied in Article 10, that must be that in national law, because you're looking at an individual vehicle.
Well, that's a moot point, isn't it?
It is, my lord, but
Because I'm not sure the European Court would agree with you about that.
well,
The
look,
European
it's
Court in Farrell, I mean, on one view, the reference to insurance obligations to the broader obligation
well, my lord,
under the article,
yes.
Which is to ensure that there is compulsory motor insurance in place in the relevant member state, including on private land and all the other things that are now within Article 3. And the body that is set up pursuant to Article 10 must provide the compensation in respect of those situations where there isn't such compulsory.
Well, Lord, we'll look at Sonka, it's particularly Sonka and Juliana on that,
Yeah.
the limits of the Article 10 body's responsibilities.
Yeah.
Usher. Is it possible to have some water,
Is
please?
there anything else in Article 10?
No, my lord. If I can go to the UK legislation,
Yeah.
which is back in the previous tab. I can pick it up in 263. Section 95, so it's Road Traffic Act 1988,
Yes.
page 263. It's simply from section 95, all I need is subsection 2. Authorised insurer means an insurer who is a member of the Motor Insurers Bureau. And then if I turn forward to 265, 143, uses motor vehicles to be insured or secured against third-party risks. Subject to provisions of this part of this Act, a person must not use a motor vehicle on a road or other public place, and unless there is enforced motor use of the vehicle by that person, such policy insurance or such security in respect of third-party risks complies with the requirements of this part of this Act. So that's the using, and then there's the cause or permit in B. then there's the criminal offence in subsection 2. If a person acts in contravention of subsection 1 above, he's guilty of offence. And essentially, the point from Vanouk is it's those words on a road or other public place, which do not comply with the obligation of the member state to implement.
So as a matter of EU law, the focus has to be on the use of the vehicle rather than where it is being used.
Indeed.
Yeah.
Indeed. Absolutely. When it's in passing subsection 4, this part of this act does not apply to invalid carriages, which looks like a 5-2 derogation, but there's no body identified so far as we're aware of. And my learned friend's point about the section, the Article 5.1 derogations, that it does seem that the UK, when one comes on section 144, we haven't found any record of the UK having made the relevant notification to the European Commission, but we see in 144 that in subsection 2, section 143 does not apply to a vehicle owned, and then various examples, I won't go through them, but local councils, the council of county or district in England and Wales, and one sees in reference there national park authorities, fire and rescue authorities, and in B, a vehicle owned by a local policing body or police authority. That's just to give the flavour, as my Lord Justice Flaux observed, there's public bodies, various public bodies as specified.
And then things like ambulances and fire engines.
Indeed, my Lord.
Yes.
Of course, I mean, as my learned junior informs me, it seems that many of these vehicles are in fact insured. And insofar as a fire and rescue authority decides we will insure our vehicles with X company, then they come within the standard regime.
Yes, and obviously this is laying down minimum requirements. There's nothing to stop
Indeed.
insurance going beyond what is required by statute.
Absolutely, my Lord, absolutely. And then if I turn forward to 273, this is requirements in respect to policies of insurance. So in subsection 2, the policy must be issued by an authorised insurer. That's the reference back to section 95. And so the policy must be issued by an insurer who is a member of the MIB.
So it's section 95.2, is it, which obliges motor insurers to be members of the Motor Insurers Bureau, because otherwise they're not authorised.
Indeed, Lord.
So that's the equivalent of the provision that was considered by the European Court in Farrell in the Irish legislation, which was said to amount to the special powers, because it's a requirement by the legislature of the member state
It is.
that the motor insurers belong to the body,
It is, Lord.
which they wouldn't otherwise have to.
Yes.
And historically, they did anyway, because that was what the position was when the MIB was set up, because it was funded by the motor insurers in the first place.
It was,
But
Lord.
this legislation, and I think predecessor legislation, specifically requires, and it's not stated in terms, but that's the effect.
It is the effect of it, my Lord, yes.
Yeah, I just wanted to check.
No, absolutely, Lord. And
In the Court of Appeal in Bern, Lord Justice Conworth refers to the obligation, but doesn't identify which section it was.
well, but this is it's a combination of these two.
Yeah.
Yeah. Okay.
And of course, and as we'll see, I mean, because you've got to be an authorised insurer to issue the policy of insurance, as we'll see from subsection 3 in 145. Of course, that being an authorised insurer is only in relation insofar as you are offering RTA insurance
Yes.
in accordance with the requirements of the compulsory obligation. So that, for example, if you were an authorised, if you were an insurer who were providing insurance limited to private land, then there's no requirement to be an authorised insurer and no requirement to contribute to the MIB. Because if you were, for example, one
But a
doesn't.
number of probably if we looked at it, and we don't have any evidence, but a very substantial number, I suspect, of motor insurers' policies cover you for vehicles on whilst they're on private land. If you think about, if you've got a 4x4 and you live in the country, it's unthinkable that you wouldn't have cover for when you drove it into a field, especially if you drive as badly as I do.
Likewise, my Lord, there may be, many quad bikes, for example, if your farm is a farmhouse with the land at the back, There's a farm I know in the Lake District on Black Combe. They have the farm, and the land is all at the back of the house. There's no other land, and they drive quad bikes and pickups around the farm, and those never go on the road.
I mean, it's no answer to the point that you could have separate insurance with another insurer who wouldn't, as you rightly say, have to be an authorised insurer. But I suspect that the commercial reality is that where there is such cover, it's provided by an authorised motor insurers.
For the majority law, yes.
I mean, in fact, the real problem in this case was that the driver simply hadn't insured his 4x4 at all, as I understand it, at the relevant time.
Well, indeed,
And had been driving it on a public road shortly before he made this extraordinary excursion into the field.
yes.
Was he actually prosecuted for this? Do we know?
He was acquitted.
He was because in fact there was a suggestion, wasn't there, that he was effectively following poor Mr Lewis because he thought he'd been interfering on at his farm.
Indeed, well, that's in the particulars of claim. But for I think I can't remember the for reasons. It's not just that he was correct in that belief, but in the particulars in the re-amended particulars of claim, believing him to have been up to no good, or wrongly believing him to have been up to no good, or something like that.
But was the prosecution for driving, or did it include the charge of driving a vehicle uninsured on the road?
We're not sure, Lord. It was for a more serious charge.
Well, I imagine he was charged with assault of some kind.
I would imagine so, Lord.
Probably GBH.
I would imagine so.
I see heads nodding behind you, so maybe it's something behind you. So he was charged with GBH, Section 18, presumably, and acquitted. Okay, thank you.
So, subsection 3 must ensure such personal class of persons may be specified in policy in respect to any liability which may be incurred by them or them in respect of the death or bodily injury to any personal or damaged property caused by or arising out of use of the vehicle on a road without a public place in Great Britain. So that's the requirement in respect to policy of insurance. I think we don't.
And none of this has been amended even since Finook.
It hasn't, Lord, no. There are discussions. I think there's quite a debate about how far Finook goes, because it's limited by, and this is not for today, this is just for the context, its use of vehicles as a means of transport. And so how far does that go? Does that include motorsport, for example, where you're driving around a track to come back to the point of where you started? Does it include farm vehicles?
Well, it would certainly include this. It would certainly include this instance.
Yes.
I mean, you might have the debate about the equivalent facts of the nuke, where you're reversing a tractor up somebody off a ladder. That's one thing. Driving a 4x4 through a field.
No, absolutely not. No bones about that. I'm not seeking to. We don't have in the bundle section 197, but I was going to. Interesting. Section 197 of the Act, it's the scope of the Act, excludes Northern Ireland from the scope of this, and that's of interest, just because we're coming on next to the MIB agreement, but there is separate provision both for compulsory motor insurance and also a separate agreement with, as it happens, the MIB for Northern Ireland. But back to the point about Article 10, it says there is a separate there's a separate provision in a Northern Ireland order, a statutory instrument, providing for compulsory motor insurance. But and then there is a separate agreement with the Northern Irish Ministry, which was the Department of the Environment, I think is now DERA in Belfast, and that agreement is made with the MIB. But it's separate provision for the compulsory motor insurance and for the Article 10 body in respect of Northern Ireland. So I come on next to the agreement, which is in tab 2.
Will you be going at any point to the Articles of Association of the MIB? I ask it simply because the judge at paragraph 16 quotes from the Objects Clause, which at its first object is to provide a safety net for innocent victims of identified and uninsured drivers to satisfy any liability required to be covered by contract insurance, ... or directive. I think you get it in tab 6 of the
Yes.
supplementary bundle, page 217. I was just interested to see that the breadth of the objects clause, which includes satisfying obligations rising out of uninsured drivers in accordance with the directive.
But we're not contending that there's any virus issue here.
No.
We're simply contending that we don't have liability. And it is, I mean, Your Lordship's right, that it is broad. The agreement in tab 2, I can start in the obligation to satisfy claims, which is 107.
Sorry, page.
Page 107. Subject clauses, clause 5. Subject clauses 6 to 17. If a claimant has obtained against any person in court in Great Britain a judgment which is an unsatisfied judgment, then MIB will pay the relevant sum to, or to the satisfaction of, the claimant, or will cause the same to be so paid. That raises the question of what is an unsatisfied judgment. That appears from the definitions section, definitions clause in 105. So about halfway down the page, unsatisfied judgment means a judgment or order, by what a name called, in respect of a relevant liability which has not been satisfied in full within 7 days from the date upon which the claimant became entitled to enforce it. And the relevant liability is back on the first page, 104. Relevant liability means a liability in respect of which a contract of insurance must be enforced to comply with Part 6 of the 1988 Act. And so the agreement between the MIB and the government is that it will satisfy relevant liabilities, which are those in respect of which there must be compulsory insurance under combination sections 143 and 145 of the Act. So, in essence, what we have, just summarising what we've been through, there are 3 relevant categories of, if one likes, uninsured case. We would say, first of all, victims, for our purposes, that is the discussion today, victims of accidents where the vehicle is subject to a Road Traffic Act requirement to be insured, but is not insured, the MIB is clearly responsible and pays. Victims of accidents with the second is victims of accidents with specified public authority vehicles, and so far as we're aware, it's the relevant public authority which pays in those cases. And thirdly, victims of accidents where Road Traffic Act insurance is not required, which for relevant purposes, in this case, because the vehicle was not being used on a road or other public place. The fate of this category of uninsured loss is the fate of this category of uninsured loss with which we're concerned. So that brings me on to the first question, which is the direct effect of Article 3. And the judge at paragraphs 95 to 101 held Article 3 to be directly effective. And there are 2 elements at issue: sufficiently clear and precise obligation. We don't challenge the judge's point, which is that Vanook might have been somewhat surprising, but declares the law that as it was back at the time when the directives were introduced. And so if one reads Vanook as if it were there back in the 1970s, then the obligation is clear and precise as to the identity of the beneficiaries and the content of the right. But the conditionality is something which we say is an important point here, because because Article 3, on its terms, expressly requires measures to be taken by the member states. Now, the respondent contends that appropriate measures have been taken, but in fact, the Road Traffic Act does not purport to be an appropriate measure in relation to private land. So what we have, in brief summary, is a form of partial implementation. Because on conditionality, you have, in a sense, three categories. You've got that conditionality, this is where there is a discretion as to national measures. You've got the case where there have been no appropriate measures. And that's, if one likes, in the cases, in the bundles, that's the Frankovich case, and also there's a case called Robbins, tab 18. I think we'll look at Frankovich in a moment. And then there's the partial appropriate measure, where member states have partially satisfied the relevant measure. And Wagner-Mire is the example of that. There's no direct effect for the part where no appropriate measures have been taken. And then you've got the cases, the third class of case, which is where the discretion has been fully exercised. That's Gara-Varan in tab 3 of the bundle, we'll go to that in a moment, and also the Hampshire case in tab 17. So, in a sense, the question on conditionality is whether the relevant discretion has been fully exercised. If I can just start on that with Frankovich in tab 19 of the authorities bundle. Paragraph 3 of the judgment.
I haven't been given what must have been the updates after tab 18. Do you have a spare?
We'll pass up.
I'm very sorry.
So, judgment A, paragraph 3.
Page 504, 5045. I'm sorry, 5405. So paragraph 3.
Thank you very much.
Paragraph 3. This is a case about protecting employees in the event of insolvency of their employer. Directive 80/987 is intended to guarantee employees a minimum level of protection under community law in the event of the insolvency of their employer without prejudice to more favourable provisions existing in the member states. In particular, it provides for specific guarantees of payment of unpaid wage claims. That's the quick summary. I think we can then move forward in the judgment to paragraph 11. So, a member state which has not adopted implementing measures may not plead its own failure to perform the obligations which directive entails. Thus, wherever the provisions of the directive appear, as far as their subject matter is concerned, to be unconditional and sufficiently precise, those provisions may, in the absence of implementing measures adopted within the prescribed period, be relied upon against any national provision which is incompatible with the directive, or insofar as the provisions of the directive define rights which individuals are able to assert against the state. Citing Becker. And then, secondly, it is therefore necessary, in 12, it is therefore necessary to see whether provisions are which determine the rights of employees, unconditional and sufficiently precise. They consider three aspects: the identity of the persons, the content of the guarantee, and the identity of the person liable to provide the guarantee. And so that the question arises whether a state can be held liable to provide a guarantee on the ground that it did not take the necessary implementing measures within the prescribed period. 13, with regard, first of all, to the identity of the persons entitled to guarantee, that is satisfied. And then 15, with regard to the content of the guarantee, that is satisfied. Article 3 provides the measures taken to ensure the payment of outstanding claims resulting from the contracts. And then, so the conclusion in 22 on those 2 points is it must be held the provisions in question are unconditional and sufficiently precise with regards to the content of the guarantee, having dealt with the minimum protection points. Then 23, as regards the identity of the person liable to provide the guarantee, Article 5 requires member states shall lay down detailed rules for the organisation, financing, and operation of the guarantee institutions, complying with the principles. The relevant principles are set out, and B, employers shall contribute to financing unless it's fully covered by the public authorities. So then the conclusions in 24 to 26 been submitted that since the directive provides the possibility that the guarantee institutions may be financed entirely by public authorities, it's unacceptable that the member state may thwart the effects by asserting that it could have required other persons to bear part or all of the financial burden. But that argument cannot be upheld. In Article 5, there's a broad discretion with regard to the organisation, operation, financing of the guarantee institutions. The fact that the directive envisages as one possibility that such a system may be financed entirely by public authorities cannot mean that member state can be identified as the person liable for unpaid claims. The payment obligation lies with the guarantee institutions only in exercising its power to organise the guarantee system that the state may provide that the guarantee institutions are to be financed entirely by public authorities. In those circumstances, the state takes on an obligation which in principle is not its own. And so accordingly, even though the provisions are sufficiently precise and unconditional with regards the two aspects, determination of the persons and the content, those elements are not sufficient to enable individuals to rely on those provisions before the national courts. Those provisions do not identify the person liable to provide the guarantee, and the state cannot be considered liable on the sole ground it's failed to take transposition measures within the prescribed period. So that's the situation, as I've said, of no appropriate measure. That's, in a sense, relative. The next situation is a partial appropriate measure. That's Wagner Mire. It's not in the bundle. During the preparation of the case, my learned friend and myself have been corresponding. There have been various supplemental authorities which had not been added to the bundle. We do have a small supplemental bundle. It might make best sense to hand up a copy of the supplemental bundle. Not all cases, they're not really, I mean, they're examples in a sense, because they're not really authorities in the same sense as those we put into the main bundle.
Yes. I mean, if you're agreed, we would find it helpful, and I'm sure we would if you're both, if you both take their view. By all means, hand the bundle up, and that will save piecemeal.
Well, indeed.
Passing up and.
That's what we felt.
Cases. No, thank you very much. In that case, let's pause for a moment while that's done.
Just going to refer briefly to Wagner Mire, which is in tab 9 of this bundle of authorities. And this is on the same directive as Frankovich. And if I can pick it up, paragraph 4 of the judgment. So a guarantee fund was established in Spain, paragraph 4. 6, guarantee fund, the case law in Spain established that the guarantee did not apply to higher management staff. And this case was about a member of the higher management staff. We see that from the first line of paragraph 7. And the first question, which is responded to in paragraph 14, was whether higher management staff may be excluded, and the answer was no. But then the third question, which in fact appears in paragraph 8, 8c, in the event that the guarantees under the directive apply to higher management staff, should the specific implementation thereof be carried out by the ordinary body envisaged for all other employees, or by means of compensation payable directly by the state? So that's the third question, which the court comes on to. It's really paragraphs 18 and 19. With regard, in 18, to the problem raised by the National Court, you point out the directive on insolvency of employers does not authorise the member states to set up a single guarantee institution for all categories. Consequently, to bring higher management staff within the ambit of the guarantee institution, established for other categories of employee. Article 3.1 leaves it to member states to adopt the necessary measures to ensure that guarantee institutions guarantee payment of employees' outstanding claims. From the discretion given to member states must therefore be concluded that the higher management staff cannot rely on the director in order to request the payment of amounts owing by way of salary from the guarantee institution established for the other categories of employee. So that's a form of partial exercise of the discretion. And then the full exercise of discretion, the example of that is gara veran in tab 3 of the main authorities bundle. Which was also on the same directive. And it was exclusion of another class of employees. It was those who either themselves or with the close relatives held over 20% of the equity in the company, in accordance with Swedish law.
Yes. So sorry, which?
This is in tab 3
yes,
of the main bundle.
Yep.
I think if one turns through the Advocate General's opinion to page 7710. Because it's doing the same directive, I think I can really pick it up. One sees the nature of the exclusion in paragraph 13, in fact, on page 7712. So it's there in paragraph 13. We see that's the last paragraph, Article 12 of the Swedish law, provides an employee who later than 6 months before the petition of bankruptcy own on his own or together with a close relative at least 20% of the company had no preferential right to wages. That was the category excluded in this case. The court considers that that is not a correct implementation of the directive, and then goes on in, if I can pick it up in paragraph 29, by its second question, the National Court asks essentially whether, where a member state has designated itself as liable to fulfill the obligation to meet claims for pay guaranteed under the directive, so that's a case where it seems that there's only one body, that's the member state itself. An employee whose spouse was owner of the company employing him is entitled to rely on the right to claim pay as against the member state concerned before a national court, notwithstanding the fact that in breach of the directive, the legislation of that member state expressly excludes from legal persons covered by the guarantee employees having a close relative who was owner of at least 20% of the shares. In 33, it cites Frankovich, so determination of the beneficiaries and the content of the guarantee is sufficiently precise. And then 36 cites Frankovich and Wagner-Mirre. The fact that those features, that's the beneficiaries and the content of the guarantee, were precise and unconditional, was not sufficient to enable individuals to rely on those provisions for national courts. And so that 37 summarises the Frankovich holding, and then 38 summarises Wagner-Mirre. But 39 distinguishes those cases. Unlike the situation described in Frankovich and Wagner-Mirre, in which the member states have still not used the discretion it enjoys, or has made only partial use of that discretion, the main proceedings concern a situation in which the main member state concerned has designated itself the person liable to meet claims of pay guaranteed under the directive. So there has been a full use, 40, of the discretion which it enjoys. So once a member state decided not to set up a guarantee, once a member state has decided not to set up guarantee institutions, consequently to determine the organisation, financing, and operation, as Article 5 of the Directive provides, and has chosen instead to provide for direct funding for public funds, can no longer be maintained that that member state must still take measures to give effect to Article 5. And so, in 42, the present case was not pursuant to the discretion which it has under the directive to exclude from the wage protection guarantee employees whose spouse was owner of the company employing them. And so that the existence in 43, the existence of discretion cannot be validly invoked for preventing direct effect. So 44. Just as a private individual must be able to rely on the right which he has under a precise and unconditional provision of the directive, when that provision is separable from other provisions of the same directive, which do not have the same degree of precision or unconditionality, that individual must be allowed to rely on provisions conferred on him in a precise and unconditional way, the status of beneficiary of a directive, once the discretion with regard to other provisions whose non-implementation was the only obstacle to the effective exercise has been fully used. And so the summary in 46, once you've designated yourself as the obligation to fulfill the, as the body liable to fulfill the obligation, then there can be direct effect. So that's the third category of cases. So turning to this directive, in terms of the identity of the beneficiaries, well, it's victims of road accidents, and Farrell 1 shows that what is now Article 12.1 of the Consolidated Directive, I think it was Article 1 of the third directive, if I remember rightly before, makes clear that all passengers are included. As regards the content of the right, as I said earlier, we take no issue on the minimum guarantee set forth in Article 9, because as the court has held on several occasions, that where one can identify a minimum guarantee, and the fact that a member state has not chosen to exercise discretion with regard to whether it might set that higher, does not prevent there being direct effect. But we focus in particular on the words of Article 3 itself. Let's just turn those up. In the supplemental bundle at tab 8.
This is the reference to measures taken by the member state.
It is.
That's the point, yes.
So with regard to the precise, what are they required to do? One can say that overall the system is designed to ensure that people are compensated, but when one looks at the terms of Article 3 itself, in terms of the Becker reference to granting rights to which individuals may enforce, when we look at what Article 3 is requiring of member states, it's take all appropriate measures. It's not to compensate, it's to ensure that civil liability in respect to the use of vehicles is covered by insurance. So what it's requiring is that there must be put in place, a system to require relevant vehicles to be insured. And we say it's plain that the introduction of that system involves a discretion as to how it's to be achieved. And we highlight that in relation to the specific issue, which is before the court in this case, we highlight what we say is a fundamental difference between vehicles on roads, where enforcement is provided by the police and the enforcement of the Road Traffic Act, it's by the criminal law, points, cameras, and so on and so forth. Off-road, on private land, it's a different matter. We make 4 particular points. First of all, it's an entirely different balance between the rights of the individual and the rights of the state on private land. Who are you to say what I can do on my own land? Well, one can see people saying. And conduct on private land being criminalised. We say that the first point is a different balance between the rights of the individual and the rights of the state, as compared with driving on roads. Secondly, the different categories of vehicles. One can think, there is, the papers below, I went back to it, it isn't in our bundle, but there was a consultation document from the Department of Transport in relation to Vanook, the impact of Vanook. And it was canvassing the sorts of vehicles in an Annex A. I haven't, as I say, it isn't in the bundle, but just some of the examples. Forklift trucks, tractors and agricultural vehicles, industrial plant, ride-on lawnmowers. One can add, I don't think it featured in this, but golf buggies. Where I live in Sevenoaks, near Seal, the golf course crosses the road. Golf buggies are used to cross the road. But the other two examples given by the Department of Transport were motorsport and dodgems. So the different categories of vehicle, there are policy decisions to be taken here. Thirdly, the different class of conduct. And for that, I do highlight motorsport, because I mean, motorsport, as one appreciate, it's a conscious decision to take risk, as compared with the risks on road, which are controlled by the road traffic rules. To what degree should the UK interfere in that? Of course, always assuming that VNUC does extend to such vehicles, because the Commission's statements on this matter have stressed the fact that the relevant vehicle it's for use as a means of transport. Whether or not that includes motorsport might be for debate. But fourthly, the distribution of financial liabilities arising out of such policy decisions. Should motor insurers insuring cars on roads be allowed to increase the premia in order to subsidise insurance provided for motorsport? Or, alternatively, should motorsport as a class of vehicle, if one can define it by reference to vehicle, should that be exempted under Article 5.2, and should there be a levy on attendance at motorsports events or participation in the sport, which will fund compensation for accidents arising out of such use? So we say that there are matters which would need to be considered, and which the Department of Transport, that's rather slowly, well, one would concede, given the date of VNUC, but there are matters to be considered. And so our submissions on Article 3 would be summarised as follows, that at the time of implementation, no one considered that the implementation obligation, or certainly in the UK no one considered, that the implementation obligation extended to vehicles used on private land. And one reason for that was a case called Clark and General Accident in the House of Lords in 1998, where the House of Lords held that the directive did not require insurance for vehicles other than on roads.
What was that case again?
Clark versus General Accident. It isn't in the bundle, Lord. It's, I can give the reference, 1998. I'm sorry, it's in the supplemental bundle.
Yeah, it's in the supplemental.
But I wasn't proposing to turn it up, because it's...
There are certainly references to it, I think, in
there are.
Either or both of your skeleton arguments.
Clark and its general accident.
Yes.
Yeah, thank you.
But and so it just...
That's the car park case, isn't it? Yeah.
It is.
Yeah.
It is. And so the implementation, it's common ground, the implementation of the UK in this case was not designed to require vehicles on private land to be insured. We say that's critical, but there was no compulsory insurance obligation imposed on them. And secondly, Article 3 does not say anything, as I've said, about payment of compensation to victims. We've got the obligation, I've already stressed, to take appropriate measures. It's an obligation to implement, but almost the context within the directive presupposes that it is not an obligation of result, certainly not one of strict result, because the existence of a requirement to have an Article 10 body presupposes that not all persons will be persuaded to insure by whatever measures are to be introduced by a member state. And this obligation, that's to require compulsory insurance, has not been implemented at all in the UK for private lands, and the relevant policy decisions have not been taken. And an analogy we believe can be drawn between, for example, if one thinks about the fact that Northern Ireland is excluded from the Road Traffic Act, and there's a separate order. And so if one posits a hypothetical example where the MIB were made responsible by government for uninsured accidents in England and Wales, that the Scottish government said, well, we will self-insure effectively, we will deal with uninsured vehicles in Scotland, And in Northern Ireland, for example, by reason of the problems at Stormont, they simply hadn't got around to imposing compulsory insurance, nor to having a body such as the MIB dealing with uninsured losses. There, we say that that would plainly be a partial implementation in such a case, and that with that partial implementation, what you could not assume is that although individuals are not required to have contracts of insurance by the law applicable in Northern Ireland, that they must be treated as having had a compulsory insurance obligation, and nor may one deem the MIB in that example to have responsibility for Northern Ireland. And
But I mean, from another point of view, the aim laid down in Article 3 is a very clear one. It is to ensure civil liability is covered by insurance in respect of the use of vehicles. We now have Vernuk telling us what the use of vehicles means. And if it is a discretion, it's really within a pretty narrow margin, isn't it? It's to take all appropriate measures to ensure that that particular aim is achieved. Is that really enough to take it into the category you've been seeking to persuade us of discretions fully, partially, or not at all implemented?
we say it is because it's designed to. We say that it's requiring the member state to take action in respect of third parties.
Yes.
Obviously, if it was something which were within the gift of the member state, then that would be very difficult for me. But here, it's to take action to require third parties to do something. And as we'll see when we come forward to Sonka and Juliana, it's that one has the coextensiveness between the requiring compulsory insurance on the one hand, and the scope of any effect against the body on the other. So that, because unless member states do impose that requirement, then effectively a body such as the MIB becomes a primary compensator. Because if there's no compulsory, for example, on private land at the moment, lots of cases coming through the system. I've seen a list of 25. I'm sure there are many more, yes. But there are cases, and many of them serious cases, where there was no requirement at all to be for those vehicles to be insured for the, well, of course, I'd say no requirement. In particular circumstances, particular cases, there may be that they were vehicles which had partly been on roads or not. But so far as the place of the accident is concerned, if their use was limited to private land, they were subject to no compulsory insurance obligation. And so what we say is that the context and scheme is designed to set up a body which is providing a residual function. And that residuality, if one could call it that, residualness, whatever one might say, that residual function only arises if there is a compulsory insurance obligation. And we would distinguish this case, for example, from the Farrell case, where insurance was required. Mr. Witty had to be insured. It was somewhere in Cookstown outside Dublin on a road called Tudor Lane, and he was driving and he hit a wall, and the passenger who was sitting in the back without a seat, the passenger who was sitting in the back without a seat was injured. And the Irish legislation said that if a passenger doesn't have a seat, then you are excluded from the protection of the contract
Irish legislation, the 1961
Yes.
Act did not require compulsory insurance in relation to passengers who didn't have a seat. That was the point.
That's right, Lord. And perhaps if we just, it's tab 6.
So what is it? You say that the distinction, of course there's a distinction on the facts, What's the distinction as a matter of law
The distinction
between that situation and a situation where somebody's injured by a vehicle on private land, and the English legislation does not require compulsory insurance for injuring people on private land, in the same way as the Irish insurance the Irish legislation didn't require insurance for passengers who were injured whilst not having a seat.
The key, my lord, is that Mr Witty was required to have a contract of insurance.
Well, so was Mr Tyndale here.
Well,
He could, in the sense that he drove the vehicle on the road before he drove it into the field.
well,
It should have been insured.
but
And it
that's but if we're dealing with it, absolutely, well, but as in terms of the I mean,
We're not dealing with a situation of a vehicle which is only ever used on private land and never ever goes on the road. In this case, he drove it on the road before he drove it into the field. And it wasn't insured when it should be.
But for the accident, for the driving which was causative of the accident, he was not required to have a contract of insurance.
Well, neither was Mr Farrell. He wasn't required to have an
Well,
insurance
but-
for people who were being carried as
Well,
passengers
my lord,
in the van.
with respect not, he was required to have a contract of insurance, but the scope did not need to extend to that class of passenger. So that the distinction we say is that for the conduct which led to the accident, Mr Witty was required to have a contract of insurance, whereas in our case, Mr Tyndale was not. Yes, I mean, of course, the Article 3 obligation is a requirement that the use of the vehicle should be the subject of a contract of insurance, or should be required to choose that. So that Mr Witty was required for the use of that vehicle at the time of the accident, he was required to have a contract of insurance. Whereas the use in the field was not required to be the subject of a contract of insurance.
Hang on, now you're confusing two things, aren't you? Because the Article 3 obligation on the state, you accept, includes use of vehicles on private land. It's the legislation that you're saying doesn't require. And your point is that, the point you just made is that Mr Tyndale wasn't required under the Road Traffic Act, section 143, to have insurance whilst he was driving his vehicle on the private land.
Indeed not. I can move on to the direct effect of Article 10. The judge didn't find direct effect of Article 10. Paragraph 70 of the judgment.
Paragraph
70.
hang on a second.
Sorry, that's the submission, recital of the submission.
Yeah.
Yes, that's the respondent's submission was that Article 10 is equally of direct effect, but it's unnecessary for his argument. And so when the judge came in his conclusions on direct effect, that's in paragraphs 95 to 101. He doesn't make a finding of direct effect of Article 10. obviously, I'm dealing with this because the respondent's skeleton in paragraph 30 submits that Article 10 is directly effective. And I deal with 2 points. The first is that Article 10 is coextensive with Article 3. That point goes to direct effect, but it also goes to the nature of the task delegated, which isn't the next point after direct effect, the emanation of state point. It's the second argument. And the second point I take is the discretion of member states in relation to uninsured losses has only been partially exercised. But just dealing with the first point, Article 10 is expressly coextensive with Article 3. If Article 3 is conditional on member state implementation, then also Article 10 is conditional because of the terms, the express reference in Article 10 to Article 3. I need to go to 2 cases, Sonka and Juliana, and I'll take Sonka first, which is at tab 8 of the authorities. Sonka was a case where the insurance company, there was an insurance contract in place, but the insurance company had gone bust.
Sorry, which?
Sonka was tab 8, Lord of main bundle of authorities, tab 8, of the large bundle of authorities. Sorry.
Tab 8.
Yeah.
Sonka, yeah, thank you.
So, just turning forward to the judgment, so there's the Advocate General's opinion first, which goes up 13 pages, but then the judgment, if I can pick it up, just noting some of the facts on page 4, paragraphs 14 to 20. So paragraph 14 starts MAV Altalanos, if your lordships have that.
Yes.
So it's an insurance company established in the form of non-profit. And then the next paragraph records that the insurance company had been declared insolvent, just at the end of the next paragraph. The applicants in 16 had taken out an insurance policy against civil liability. So 19 brought an action for damages against Magyar Alam based on the loss.
Hungarian state.
Yes, based on the loss which they had claimed to suffer as a result of incorrect transposition of the first directive into Hungarian law. And the applicants in the main proceedings submit that though Hungarian law provides with effect from 1st of January 2010 for the payment of compensation by a body responsible for providing compensation for the damage caused by an insured vehicle in cases where the insurer is insolvent, so the law had subsequently been amended to include this category of case, that measure does not apply to civil liability arising out of accidents which took place before that date, such as the accidents for which they're liable. The question was whether this was required to be within the scope of the relevant body's responsibilities prior to changing the law. So turning over, it deals first of all with the scope of the obligation in Article 3, and so 24. Article 3 wants framed in general terms. This requires each member state to take all appropriate measures. As the Advocate General states, it's clear from that provision that member states are required to establish in their domestic legal systems a general obligation to insure vehicles. View of the breadth, 25, of the wording, the scope of the obligation thus placed on member states must therefore be defined with view to the context and objectives of that provision. So 28, Article 3, read in the light of the later directives, requires each member state to ensure, subject to the derogations allowed under Article 4, that every owner or keeper of vehicle takes out a policy with an insurance company for the purpose of covering, at least up to limits, his civil liability. And then that's said in 29 to be very important. 30, the payment of compensation by such a body was therefore considered to be a measure of last resort. Perhaps in fact, that really follows from 29, so I'll need to read 29. Importance moved it to supplement those provisions by requiring the setting up of an Article 10 body. And so the payment in 30 by such a body was therefore considered to be a measure of last resort, envisaged only for the cases in which the vehicle that caused the injury is uninsured and identified who has not satisfied the insurance requirements referred to in Article 3.1. And then 31, as regards determination of the actual circumstance in which the insurance obligation laid down may be regarded as not having been satisfied, it is significant, as the Advocate General stated, that the European Union legislature did not confine itself to providing the body must pay compensation in the event of damage caused by a vehicle for which the insurance obligation had not been satisfied in general. So it wasn't a general guarantee, but made it clear that that was to be the case only in relation to damage caused by a vehicle for which the insurance obligation provided for in Article 3.1 First Direct has not been satisfied, that's to say a vehicle in respect of which no insurance policy exists. Such a restriction is explained by the fact that Article 3.1 requires each member state, subject to derogations, to ensure that every owner or keeper takes out a policy with an insurance company for the purpose of covering the civil liability. So that's, in a sense, because when one looks at the previous sentence, the insurance obligation provided for in Article 3.1, it looks as if that's referring to an EU obligation in respect to a particular vehicle. But of course, as stressed in the next sentence, what Article 3.1 is doing is, of course, requiring each member state to impose that requirement on individual drivers so that each vehicle has the requisite insurance cover. And over the page, viewed in that light, the very fact that damage has been caused by an uninsured vehicle attests to a breakdown in the system which the member state was required to establish and justifies the payment of compensation by a national body providing compensation. And we stress that term, a breakdown in the system, because we would ask rhetorically there, if the member state has not put in place a system for private land, it's not a breakdown in the system, it's a failure to provide for a system in respect of that class of, that part of the territory. And so 32 follows from the foregoing that contrary to the line of argument put forward by the applicants, the payment of compensation is provided for cannot be regarded as the implementation of a guarantee scheme in respect of insurance against civil liability. Rather, it's intended to take effect only in specific, clearly identified sets of circumstances. So it's not a general guarantee scheme. The insolvency of an insurer does not constitute a case which can be identified as one of those sets of circumstances. In such a situation, the insurance obligation has been satisfied. So we're back to the point which my Lord Justice Flaux picked me up on when I was going through the articles as to the nature of the insurance obligation, that two-tier aspect to it. The obligation on the member state, but the member state must impose that obligation on individuals so that there is an insurance obligation on the driver of the relevant vehicle. Because it's the fact that there was such an obligation in this case.
On the interpretation of Article 3 by the European Court in various cases, there is an obligation on the member state to require compulsory motor insurance for use of vehicles off-road.
Yes, absolutely.
Why is that sentence in 31 not equally applicable here? Viewed in that light, the very fact that damage has been caused by an uninsured vehicle, which it has, attests to a breakdown in the system which the member state was required to establish, and justifies the payment of compensation by a national body providing compensation. What they go on to deal with on the facts of the case is a different scenario where they have established compulsory insurance, but the insurer goes bust.
But what we
It's
say
a different scenario.
what we said, absolutely, my Lord. I'm not saying that the facts, obviously the facts, it's a different case, but it's the breakdown of the system. It's member states must set up that system to provide for compulsory insurance.
But we failed to do that, and that's a breakdown of the system.
Well, Lord, with respect, not. The system which we have set up does not extend to private land. We have not set up a system.
But we're obliged to.
Yes.
We should have done, and we haven't.
Surely
Yes.
it's the system contemplated and required by the directive which matters.
So,
Well, Lord,
it's no answer to say, well, the acts, we've complied with the act. It's an entirely circular argument, Mr. Mercer. Here what they're talking about here, in paragraph 31, true it is, it's what we would call obiter. But what they're talking about is whether or not the member state has complied with its obligation under Article 3 to set up the system of insurance, compulsory insurance, for the use of motor vehicles. Where it hasn't, there's a breakdown in the system. And that's what this case is all about.
Well, with respect, where it hasn't set up a system, so Lord, if,
Where it hasn't set up a sufficient system.
well, because I mean, so that what your lordship's really putting to me is that if, in my example about England, Wales, Scotland, Northern Ireland, simply there were no compulsory insurance order in Northern Ireland, and there were no arrangements made for uninsured losses in Northern Ireland, that there would be a breakdown in the system which the member state has set up. I mean, with respect, Lord, that on our case, that would be a failure to implement the obligation to provide for a system in that case.
That's semantics with respect.
Well,
Two different types of breakdown. One of them is more serious than the other. And the example you give, the Northern Irish example you give, is a very serious breakdown of the system. Because it's a failure, a complete failure, to put a system to ensure that the system you do put in place covers the entirety of your territories.
well, Lord, with respect, we say that the private land taken to, I mean, the exclusion of private land is of a similar nature, because it's leaving out of account a whole range of category of vehicles on large tracts of the land. And we do stress the way in which the European Court in 31 explains Article 3.1 as imposing the obligation on the member state. And we say that it's contemplating.
So you say it's a failure to put in place a system at all, as opposed to a breakdown in the system?
It is, Lord. Yes, we do. And if one looks, on the facts of this case, of course, the fact was that the driver in question had taken out a policy of insurance. But that policy of insurance was taken out pursuant to the member state requirement to have in place a contract of insurance. And so there, the insurance obligation had been implemented to require that. And so we're back to the insurance obligation, having that operating at two levels. What member states are required to achieve, but then looking at what is in fact, what system is set up by the member state.
In fact, am I not right in saying, and it's a different point, but where motor insurers become insolvent in this jurisdiction, the liabilities are picked up, are they not? Is it by the MIB or is it distributed between the other insurers? And the last time a motor insurer went bust was Vehicle in General, I think, a long time ago.
It's the financial...
Junior knows.
The FSCS would normally pick it up.
Sorry?
The FSCS would normally pick it up as I'm being prompted. The Financial Services Compensation Scheme
Financial Services Compensation Scheme. Yeah.
would normally pick it up.
Our agreement, the uninsured drivers agreement, technically pick it up, but ultimately it's passed on to the Financial Services Compensation Scheme.
The uninsured drivers agreement would technically pick it up, but it is passed on to the Financial
That's
Services
what I thought.
Compensation Scheme.
Because I think this has happened in the past. I think there's some recollection or some litigation involving Vehicle in General. But it's a long time since I looked at the policies. Don't worry about it, Mr. Mercer. It's not relevant for present purposes.
Then the second case, Juliana, tab 16. This was a case where a lady in Portugal had taken a car off the road, and her son, unfortunately, and so she hadn't insured it because it was off-road and she wasn't intending to use it, but unfortunately her son took it, used it, and was involved in an accident. That's Juliana. In tab 16, if one turns through the Advocate General's opinion to the judgment, in page 3 of the judgment, towards the end of the tab, paragraph 8, One sees a brief summary of what the Portuguese law was. And it provides that every person who may have, this is in paragraph 8, the relevant provisions provide that every person who may have civil liability to pay compensation for financial damage and non-financial damage deriving from damage to property or personal injuries caused to third parties by land-based motor vehicle must, to enable the vehicle to be used, be covered in accordance with provisions of that decree law by insurance covering that liability. So that was the Portuguese provision. The
So she wasn't required to have insurance because the vehicle was disabled.
It was off-road, but it wasn't disabled.
Well, I'm not sure of that. I thought somewhere in the judgment it looks as if it was, and but the son had done something to make the vehicle start again. I don't know why I think that. Anyway.
Because I think, I mean, paragraph 18, your Lordship may well be right, but in any event, she had taken it off-road.
Yeah.
It doesn't relate whether there was some sort of statutory declaration or not, but she'd taken it off-road. In paragraph 18 suggests that she didn't intend it to be used, and she submitted that she wasn't under an obligation to take out a contract of insurance against civil liability. The 17, having paid the compensation to those entitled to such through the passengers of that vehicle for the damage and injuries, the fund brought an action against her for recourse to for the damages paid out. And then 26, the referring court appears to consider there's no obligation to take out insurance covering the civil liability related to the use of the vehicle in question. And of course, as in many of these cases, it's an interpretation case, interpretation of the EU provisions, and presumably that on the basis that once the EU provisions are interpreted, then the national law provisions can then be interpreted in consequence, because one's seen in paragraph 8 the fairly broad terms of the national provisions. In paragraph 33, the court asks whether the interpretation of the directive is that the taking out of a contract for insurance is obligatory when the vehicle concerned is parked on private land solely by choice of the owner who no longer intends to drive the vehicle. 36, so Article 3 is in broad terms, is worded in very general terms, Sonka. Accordingly, each member state must ensure that, I would suggest, is by creating national legal obligation, but subject to the derogations provided for in Article 4 of that directive, that every vehicle normally based in its territory is covered by a contract concluded with an insurance company in order to cover civil liability arising as a result of the use of that vehicle. 41 cites then Vanouk and the later cases, Andrade and Torero. The fact that the court held, in essence, the judgments mentioned, this is paragraph 41, in the preceding paragraph, that only situations of use of the insured vehicle which fall within the use of the vehicle as a means of transport, therefore within the concept of use of vehicles within the meaning of 3.1, may give rise to the insurer being responsible under a contract of insurance against civil liability in respect to the use of that vehicle. Does not in any way mean that the determination of whether there is an obligation to take out such insurance should be dependent on whether or not the vehicle at issue is actually being used as a means of transport at a given time. And so the holding on this is that it's 42, the vehicle which is registered, therefore has not been officially withdrawn from use, which is capable of being driven, corresponds to the concept of vehicle, does not cease to be subject to the insurance obligation on the sole ground it no longer intends to drive it and immobilise it.
That's
Lord, yes.
She had immobilised it in some way.
Yes, indeed.
It's slightly obscure on the facts, but it looks as if he did something to it to make it start again, which is why they say it's capable of being driven.
Yep. Over the page, the important part is an argument by the UK and others, which was rejected. We'll see how that was done. 43, the argument is summarised. So a broad interpretation of the scope of the general insurance obligation is not necessary, so the UK, so that one could limit the Article 3 requirement on member states to exclude such vehicles, since compensation for the damage or injuries which occur in circumstances such as those at issue could be paid by the Article 10 body. So they're saying Article 3 can stay fairly narrow because you've always got the Article 10 body, and that's good enough. The court rejected that submission, and we'll see why. We'll see the basis on which they did that. So 45, well, 44 recites Article 10. 45, the payment of compensation was designed to be a measure of last resort, envisaged only for the situations referred to in that provision, and cannot be regarded as the implementation of a guarantee scheme in respect to insurance against civil liability relating to the use of vehicles otherwise than those situations. Citing Sonka. 46, as the Advocate General states in paragraph 34 of the opinion, the scope of the obligatory intervention of compensation body referred to in Article 1.4 as regards damage or injuries caused by an identified vehicle, is therefore coextensive with the scope of the general insurance obligation laid down in Article 3. The obligatory intervention of that body in such a situation cannot therefore extend to situations in which the vehicle involved in an accident was not covered by the insurance obligation. So, in referring to the vehicle involved in the accident, submit that that must refer to the individual vehicle, and therefore it must be covered as a matter of national law by the insurance obligation. And then the next paragraph, the interpretation, it said in the second part of the paragraph, guarantees those victims.
Well, I'm not sure about that, because what they're dealing with is they're objecting the argument of the United Kingdom and other governments that you could interpret Article 3 in a narrow way because you've always got Article 10. And what they say it's coextensive, and therefore, and that's what that last sentence of 46, the obligatory intervention of that body in such a situation cannot therefore extend to a situation in which the vehicle involved in an accident was not covered by the insurance obligation. That looks to me to be the insurance obligation on the member state under Article 3. That's what
Well, clearly, my Lord, this case is dealing with the scope of Article 3 as a matter of EU law. What's to be the requirement on a member state? And so, but insofar as it's envisaging, Article 3 envisages measures to be taken by a member state, the system to be set up, and the insurance obligation to be imposed on each vehicle. And so, well, obviously this case is not dealing with the question of whether this is, well, it's not saying it's a matter of national law. But if one considers the position of the individual vehicle, whether that's required to be covered, it's the second subparagraph of Article 3 that you've got to look to the terms of the in Article 3, your Lordships will remember the extent of liability covered, terms and conditions should be determined on the basis of the measures referred to in the first paragraph.
47 is then in much broader terms, isn't it? Because 47 is saying that their interpretation of the directives, which include an endorsement of the Nuke case, and make it possible to ensure the attainment of the objective of protecting the victims of accidents caused by a motor vehicle, laid down by the directives concerning insurance, etc., etc. That interpretation guarantees those victims are in any case compensated either by the insurer under a contract entered for that purpose or by the body such as the MIB, where the obligation to insure the vehicle has not been satisfied.
That interpretation in terms of the obligation it imposes on member states, yes.
Yeah.
But in order to, I mean,
That's expressed in terms of the directive, the obligations under the directives rather than the obligations under the national
well,
legislation.
it is, my lord, but we can't. I mean, if you're asking yourself, am I required to be insured? You don't look to the directive. You've got to look to your national law. And so the insurance obligation, so far as the individual vehicle is concerned, is not a matter of the directive. It's a matter of the national law. It's a matter of the national measures. 50, and then the vehicle was subject to insurance obligation. And 52.
But the context, Mr. Minister, is the directives 3842 is all about how you interpret specifically Article 3.1.
But of course, the context is because it's trying to define it's trying to interpret Article 3, which is the scope of the obligation on the member state, not the scope of the obligation on the driver of the vehicle. If I can just draw attention to the Advocate General's...
So then in 52 they go on to say that on the facts of that case there was an obligation to have compulsory insurance in place under Article 3.1 of the first directive.
But that can only be on the basis, my lord, that that the articles in paragraph 8 of the judgment of the Portuguese law can be interpreted to comply with the obligation. And in paragraph 8, they are it looks as if they are capable of interpretation which would require that.
But the obligation would be there under the directive, whether or not the national law can be interpreted so as to comply with it.
Well, Lord, with respect not on the individual vehicle. Because otherwise, if I'm to drive a vehicle, I don't look to the directive as to see whether I'm required to insure that vehicle. I look to the national law. So the obligation is there on the member state, yes, but not on the driver of the vehicle.
But the court is not purporting to deal with the position under the national law at all. That's not part of its function. It actually says that so far as I think it says somewhere, doesn't it, so far as the national court was concerned, Mrs Juliana wasn't under an obligation to have insurance. So this is all, none of this is about the Portuguese law, this is all about the directive.
Yes, but in 52, the insurance use is obligatory in the sense that member states are required to provide for that. But the Advocate General, back in page 8 of the opinion, at 33 to 35, first of all, 33 quotes Sonka, says if a situation does not fall in the scope of the obligation to insure, as defined under Article 3, the compensation body will not be required to provide a safety net under Article 1.4 of the second directive. In other words, the potential scope of intervention is coextensive with the obligation to insure. Member states may gold plate, but that's not a mandatory requirement. It follows from the above points. The first and second directive distinguish between, on the one hand, the large majority of situations where an individual taking out insurance must bear the cost of the risk associated with the use of vehicles. And the other, the marginal or residual situations where the cost of risk is borne by the society at large, or, as he says in the footnote, in accordance with the relevant provisions. That is, by the intervention of the compensation body. However, to the extent that there is no insurance obligation at all, the basic consequence is that the risk may end up being borne by the victim of the accident, particularly in situations where, due to seriousness, the amount of compensation is considerable, where the victim cannot obtain adequate compensation due to the insolvency of the person liable for the accident. Of course, he's talking about this in the context of how do we interpret Article 3? Does it have an extensive meaning or is it narrower? And the risk of making it narrower is that parties would not be covered. But to the extent that there's no insurance obligation at all, and we say that obviously that must be in accordance with the relevant insurance obligation on the particular vehicle as implemented. So the coextensiveness of Article 3 and 10 obligations defines the scope of an Article 10 body's obligations as being residual. And we would say that this residual nature of liability is important from a practical perspective. So on roads, MIB insures those cases where motorists commit a criminal offence of having no insurance. On private land, MIB would be the primary compensator and not simply having a residual liability. This means that even if there were a direct effect of Article 10, well, I'll leave that to later. So that the second point we make on Article 10 is that has there been a full exercise of the member state discretion in relation to uninsured losses? Hampshire at tab 17 is right. Well, perhaps in view of time, I think my learned friend is going to go to that. He relies on Hampshire, but Hampshire was a case involving the pension fund picking up the liabilities of pension funds where employers are insolvent and there is insufficient provision in the pension. And the issue in that case was that the identity of the person liable to provide protection had been determined and had been clearly determined. And that's, whereas in this case, we would say that there are two main classes of uninsured losses: the general uninsured losses which go to the MIB, the uninsured losses from Article 5(1) or 2, and in respect to 5(1), we know that those obligations are picked up by government in a way one can call it, a form of self-insurance. But up until Vanook, what the UK implementation was the known world, if one likes, for the uninsured losses for which persons were responsible. So the inclusion of private land within Article 3 gives rise to the need for these policy decisions of which I've spoken, and the possibility of derogation. And Article 23 in the directive, I can just turn up in the supplemental bundle, Article 23 in tab 8 of the supplementary bundle, which is dealing with information centres.
Yes.
Expressly contemplates that there will be information about the relevant guarantee body. And so Article 23 on page 306, in order to enable the injured party to seek compensation, each member state should establish or approve an information centre, and that must have a register containing information, and 4, a list of vehicles in which in each member state benefit from the derogation in 5(1) and 5(2). And then 5, as regards the vehicles provided for in point 4, that's the derogation vehicles, the name of the authority or body designated in accordance with the third subparagraph of 5(1), and so that in our case would be the relevant public authorities. And secondly, the name of the body covering the vehicle in the member state where it is formally based, if the vehicle benefits from the derogation provided for in Article 5(2). That's the type of vehicle exception. So that what's contemplated is the information centre will be giving information about which body it is under Article 5(2) derogation. It simply shows that what is contemplated, as a matter of the context of the directive, is the possibility of, or certainly the strong implication is that there can be more than one body providing such compensation. The final point on direct effect is that the approach of the CJU, for example in the Frankovich case, is to apply the conditions for direct effect and then to move on to consider the remedy. There's a similar picture we see in Smith and Mead, 2018 case which followed Farrell and Witty. The complaint implicit in Muller and Friends submissions is that the Frankovich damages would give rise to a higher hurdle. We say that's not relevant in determining whether the relevant provisions of direct have direct effect. The damages remedy, the Frankovich remedy, is simply a consequence of the determination or not of direct effect.
Right, because if you're right in your argument that the provisions don't have direct effect, then whatever remedy the claimant has, it's a remedy against the government and not against you.
Yes, indeed.
If there's a consequence of the law in relation to the Frankovich claims, they can't bring a claim or they can't achieve their settlement. That's not my opinion on that.
The second point.
No answer to say, well,
No.
it's unfair. Of course it's unfair in one
Indeed. Indeed, and one sees in Frankovich the court saying, well, there's no body rather than body being set up. That's why we're inventing the Frankovich damages as an EU remedy. And in Smith and Mead, similar. That the Smith and Mead was the Farrell and Witty situation, but in respect of there was a private insurer there. The private insurance contract had wrongly been interpreted to delete the exclusion of Smith and Mead. And the consequence was the court went straight on to consider, well, the remedy is against the member state. But if I'm wrong so far, so if there is direct effect, what's the practical consequence? I mean, the default position is that unless you're within the specific EU law cause of action, such as Frankovich damages, it's for national law to determine remedies subject to compliance with principles of equivalence and effectiveness. And that's, I won't go to it, but the Wells case and the bundle, that paragraph 62, 69, deals with that issue, the notion of procedural autonomy. So the remedy is in principle for the member state. But my learned friend here argues, and the judge found, that it's not necessary to have recourse to general approach to remedies, because a combination of direct effect and emanation of state is said to lead to the MIB being liable for the results, effectively, of the legislative failing of the member state. The judge encapsulated this submission in the final sentence of paragraph 131, when he said that when he held that the effect of EU law is to treat the designated body as if the obligation imposed on the state had been delegated to it in full. It's in the slim core bundle. I'm just not going to it because of time, but it's in tab 6 at page 73.
There's nothing particularly surprising about the proposition. The MIB of Ireland was held to be liable for the legislative failing of the state, in the sense that it had to pay the compensation in circumstances where the state had excluded it from a legislative requirement.
Well, as I've said, we distinguish Farrell. I'll go to the Farrell.
I know you seek to do that, but in terms of the position under EU law, there's nothing particularly surprising about the result.
Well, we simply say that I think I made the submission in terms of difference, that there was a compulsory insurance obligation imposed on Mr Witty, whereas here there isn't. So, but in effect, the proposition against me is that there's a freestanding remedy against the MIB.
Well, you might have, there are all sorts of issues which haven't been explored as to whether you'd have some right of contribution over against the government.
Indeed, that's not for today. Yes.
But I mean, obvious point, to the extent you say, well, this would leave the MIB as a primary compensator. Well, I see the force of that point, but on the other hand, I can see all sorts of arguments as to why the government should end up being liable at the end of the day.
I'm going to address those on another occasion, but it's not for today. But but we say, I mean, in response to the judge's point, that the liability of the Article 10 body, we rely on the coextensiveness of that with what we say is the insurance obligation as implemented, and I've made that point. But that leads into the next point, which is that the MIB has been delegated with a limited task in this case. And the liability sought to be imposed on the MIB falls outside the scope of that delegation. So I need to go to Farrell and Witty number 2 at tab 12 in the authorities bundle. And pick it up in the judgment almost at the back of tab 12, because we are, I mean, in terms of the pure question of emanation of state, then we are in a relevantly similar situation to the MIBI.
Yes. I mean, you don't dispute that for certain purposes you have to be treated as an emanation of the state, as
Yes.
I understand it.
Yes.
So the argument is whether that case is distinguishable on the facts because of the other points you're arguing.
Indeed.
Yeah.
And so if I can pick it up in the judgment, because we know the facts, it's really the 1230, paragraph 35, having said that such organisations or bodies may be comparable to the state in paragraph 34, accordingly, a body or an organisation, even one governed by private law, to which a member state has delegated the performance of a task. And what we'll be stressing is the limited delegation here reflects the limited powers, which possesses for that special purpose special powers beyond those applicable between individuals. 37, the importance attached by the legislature to the protection of victims led it to supplement those arrangements by requiring member states to establish a body with the task of providing legislation, at least up to the limits. Therefore, in 38, the task that a compensation body such as MIBI is required by a member state to perform, a task that contributes to the general objective pursued by the EU legislation relating to compensatory insurance, must be regarded as a task in the public interest that's inherent in this case in the obligation imposed on member states. So it is a public interest task. 39, in that regard, it must be borne in mind that in case of damage to property or personal injuries caused by a motor vehicle for which the insurance obligation provided for in Article 3.1 has not been satisfied, the court has held the intervention of such a body is designed to remedy the failure of a member state to fulfil its obligation to ensure that civil liability in respect to the use of motor vehicles normally based on its territory is covered by insurance. That's the breakdown point, the breakdown of the system point. So, looking at the task which has been delegated to the MIB here, the task is to pay compensation under the 1999 agreement. It's to pay the relevant judgment in respect to the relevant liability.
It's the breakdown of the system point, Mr. But that paragraph 39 is expressed in quite general terms, isn't it? About it's referring to the failure of a member state to fulfil its obligation to ensure the civil liability in respect to the use of motor vehicles is covered by insurance. That is going back to what you submitted in relation to SONCA, where you try to say it's a failure to put in place a system at all, as opposed to a breakdown of the system. It seems to me 39 of Farrell number 2 will cover both.
Well, in principle, but 39 of Farrell number 2 is purporting to summarise SONCA.
No, it's not. It's simply citing SONCA as an example of a case in which that principle has been
with respect, Lord, in referring to SONCA's case, paragraph 31, it's seeking to summarise what comes from SONCA. So we say for the true meaning of that, go back to SONCA. But I acknowledge, my Lord, it is capable of a broader reading than the equivalent paragraph in SONCA.
I mean, it's a familiar problem when interpreting EU judgments. It's a question of whether it is just a building block intended to reproduce pre-existing authority, but not to develop it in any way, or whether it, at the same time, perhaps it's intended to indicate an extension or development.
Well, indeed,
Which doesn't always make our task any easier, but that's...
So we stress in terms of what task has been delegated to the MIB. It's the RTA liability. And so that makes the task for the MIB coextensive with the scope of the compulsory insurance as implemented by the UK. Because as we know, it's limited to road or other public place. So this task then carries through to the funding of the MIB, because it's only those insurers who underwrite compulsory motor insurance who are required to be members. And such members, as it's in the papers in Mr. Ryman Tubbs' statement, I think it's paragraph 31, or around paragraph 31, such members pay a levy proportionate to the premium income, and it is only the element of the premium resulting the risk arising out of compulsory cover required by the 1988 Act, which is used to calculate the levy. And so what one has from a sort of combination of putting together the agreement and the RTA provisions is a clearly defined task limited to claims where the compulsory insurance requirement of the RTA has not been satisfied. And so to summarise 3 points on Farrell and Witty, the first is that the one I've already made, that compulsory insurance requirement in Article 3 had been implemented in respect to the use of vehicles. The use was required to be covered by insurance, so Mr. Witty had that legal obligation to have the insurance policy. in respect of the driving which caused the injury. And here there is no relevant compulsory insurance obligation for the driving which caused the injury in our case. Secondly, in Farrell, the Article 10 responsibility had been delegated to the MIBI, so that if Mr Witty, for example, had hit a pedestrian on the roadway he was driving, the MIBI would have had to respond on the agreement. Here, there's never any agreement for the MIB to deal with damages arising from the use of vehicles on private land. And thirdly, in Farrell, the claim was funded by insurers who benefit from the general obligation to insure, to which Mr Witty was subject. Here, the claim will be funded by, if you were against me, by the insurers of the RTA liabilities, who are not necessarily also insurers of vehicles on private land.
Although you accept that in reality that would be.
I accept that a large number of private motor insurance policies.
The Farrell point, because the point in Farrell, the point that we made against you is, well, in Farrell there was no obligation under the Irish statute to insure passengers who were rolling around in the back of vans and not sitting in the seat with a seatbelt, etc., etc. And that as a consequence, presumably, motor insurance premiums were lower than they would otherwise have been, so that the motor insurers weren't getting the full premium. Therefore, the money, the levy that was being levied against them by the MIBI was lower than it would be if there was an obligation to cover.
And so we're back.
Future, and that's obviously, it's not an answer to your point, but
yes, I mean, yes, Lord.
at
Yes.
the end of the day, in practical terms,
Yes.
if you're wrong in your argument, and the MIB is liable in this case and in other similar cases, then the MIB will levy further, will have a further levy on the insurers.
Yes. But I mean
Or presumably, if the government ever get round to it, there might be an amendment to the legislation, then an amendment to the MIB agreement.
Well, exactly. I mean, but I think I say yes. Of course, one must be cautious about that because the MIB agreement is something which is negotiated.
Yeah.
I mean, for example, in Northern Ireland, the Northern Irish Department of the Environment might have decided to deal with somebody else, and the MIB may not have covered. I mean, there may have been times in the past when it may have been not particularly advantageous to cover Northern
I'm
Ireland.
slightly troubled by your constant reference to Northern Ireland.
It's an example.
That we don't know the precise legislative history of the position with compulsory motor insurance in Northern Ireland. And amongst other things, we don't know whether it has some connection with the position in the Republic. Because it occurs to me that I don't know the answer to that question. And I think I'm right in saying that the Road Traffic Act 1930 was the first act to introduce compulsory motor insurance, which of course is after Irish independence, although the Republic of Ireland was still it was a dominion, was it not?
Sorry, Lord?
It was a dominion, or it had a special status between 1922 and 1949.
Yes.
So there may be some. That's why I say I'm.
And of course, one must.
I don't want
No.
to be.
Most of my reference to Northern Ireland is to cite it as a
just
possible category, a hypothetical.
Example.
It's a hypothetical example, although one sees that. I mean, I think what I say on that is it's a hypothetical example, but what it does show is that a member state could decide that for a part of its territory, different rules will apply for the compulsory insurance obligation, and it can engage another body to deal with that. But it's mainly been hypothetical, so I'm not seeking to make much of it. I mean, I noticed, but I already had that point in my notes when we noticed that in fact it was excluded from the compulsory insurance requirement, but I'm sure there's historical reason for that. The final point, I think, is just to go to Smith and Mead to look at it's in the supplemental bundle of authorities. It's tab 10.
Yeah.
And it summarises in paragraph 8 on page 1840. This is the Court of Justice judgment. Summarise the effect of Farrell and Witty number 2. Individuals may rely on the first.
What page, Mr.
So this is page 1840.
Thank you.
And so just summarising the effect of it, effectively, it's Farrell and Witty number 1 and number 2. Individual may rely on the first on what is now Article 12 against a body which Ireland, on which Ireland has conferred the task in public interest, which for that purpose possesses by statute special powers. Then the facts are summarised. I don't think they need to detain us very much. The 14 records that Mr Mead had a motor insurance policy with FBD. Smith, that was a, and that the policy contained the same exclusion as in Farrell and Witty. Smith sued Mead, and FBD, Ireland, and the Attorney General were joined. And the upshot of the proceedings was that so FBD refused to provide indemnity in 16, and then the High Court of Ireland applied mar-leasing and went even further, because in the last sentence of 17, the High Court declared the exclusion clause in the insurance contract taken out by Mr Philip Mead to be void. So effectively applying mar-leasing to the insurance contract, and that the European Court held was not legitimate. But 18, there was a settlement agreed between FBD and Smith, so FBD paid out, and then FBD in 20 appealed against the judgment, claiming that the High Court had misapplied the law on mar-leasing. The effect of that judgment, that order was confirmed. The third directive form of direct horizontal effect, given that FBD has a status of a private person. And then FBD stated if its appeal was upheld, it would seek to recover from the Irish state the amount that it paid to Mr Smith. And that point was upheld. So 45, national courts obliged to set aside provision of national law only where that directive is relied on against a member state, which FBD was not.
I'm sorry, this is ignorance on my part, but what was the actual point at issue in Smith and Mead?
So, I mean, the main point of issue was whether the exclusion clause in the insurance contract for passengers without seats,
Yes.
whether that was void, as the judge held,
Yeah.
as being in breach of EU law or not. That was the main point.
Horizontal direct effect.
Horizontal direct effect.
Yes.
Yes, indeed. And the court held.
If it helps, it's paragraph 30 of the judgment.
Yes, thank you.
And so 40.
Paragraph 30.
Yeah.
Hang on a second. Yeah.
Yeah.
So the court has no difficulty in rejecting that at 45, saying that direct effect is against member states and emanations of state,
Yeah.
not against the insurance company. And then 54, it considers whether it might apply to one of the limited extensions to direct effect in the CIA security case, and held that it shouldn't in 54. And so 55, in the light of the foregoing, it must have concluded that in the main proceedings, the referring court, which considers unable to interpret section 65(1)(a) of the 61 Act, Article 6 of the 60 Regulations in a manner that's compatible with Article 1 of the Third Directive, is not obliged, in order to determine whether Mr Smith was entitled to claim, to disapply solely the provisions of that Third Directive, those provisions of national law, as well as the exclusion clause, to be found as a consequence of the provisions in the insurance contract, thereby to extend the possibility of relying on a directive to the sphere of relationships between private persons. And then, the result is into Frankovich in 56.
Yes.
So just pick up
Yes.
60 to 63 of the Advocate General. back on page 1835, first of all, noting in 60, once the direct effect of the Article 1 3rd Directive has been acknowledged, there's therefore no doubt as to whether FPD may rely on that provision against the Irish state in order to supply the national provisions which are contrary to that directive. Where it is possible to rely on such provision against the emanation of states, such as MIBI, the same as to a fortiori be possible against the state, converse against the public authority. It follows, therefore, in the proceedings for the referring court, FPD is entitled to rely on Article 1 3rd Directive in order to disapply the Irish provision, the exclusion for this particular class of passenger. If, 62, if in the Irish system the payment of subsidiary compensation by the guarantee body is not provided for, where the owner of the vehicle has an insurance policy, we do say that that's important. It's not talking about deeming the MIBI to have a wider responsibility than it actually has. So not provided for where the owner of the vehicle has an insurance policy, and that policy does not cover a particular risk. He refers there to SONCA, which ought nevertheless to cover if the state had correctly transposed, it falls to the state to bear the financial consequences. Contrary to what Ireland seeks to have recognised, disapplication of national provisions, contrary to Article 1 of the 3rd Directive, cannot have the automatic consequence of imposing on the insurer the responsibility of compensating Mr Smith. But 62 does seem to contemplate, it relies on the scope of the task actually delegated to the Article 10 body. It's not saying there that regardless of what has been in fact delegated to the MIBI, the MIBI should be deemed to have a wider responsibility than it has actually been delegated with.
Yes, and I see on one reading anyway that could provide some support for your argument. I mean, do we find that point picked up in the judgment of the court?
It is not picked up in the judgment of the court.
No, just the court do identify the claims Frankovich. They don't suggest a claim against it might be liable.
Yes, I mean, the juniors are saying, of course, that the remedy identified by the court at 56 is Frankovich.
Yes.
So I suppose in a way,
yeah.
it doesn't identify a remedy. If Malone and Friend were right, then the court would be, well, the court ought to be making the point, and so should the Advocate General, that direct effect against the MIBI is possible in this case, to provide a right to payment. So those are our submissions.
Well, if there wasn't a claim against the MIBI,
True.
presumably because what in fact happened, the FPD had indemnified
FPD had paid out.
paid out claims, and therefore this was really a dispute between FPD and the Irish state.
Well, certainly the Irish state had been joined and MIBI had not been joined. That's correct, Lord.
I mean, it's effectively, it's the point that I was making to you earlier about on what basis there would be claims over against the government. Because obviously if the MIB were obliged to indemnify Mr Lewis, then they will have rights of subrogation in respect of any other claims he might have, for example, for Frankovich damages, which is exactly what Smith and Mill demonstrates.
Indeed, my Lord. But paragraph 62 is contemplating the limited delegation to the MIBI.
Well, it might be said against you, and my lord's already made the point, this particular point doesn't seem picked up by the judgment, but to the extent that Advocate General Ball is advocating a narrower approach, it is a narrower approach than Advocate General Sharpston and Farrell and Witty, because I can take you to several passages in her opinion which give much broader interpretation of this particular issue. So I'm not sure, the point I'm making is we're not really assisted by the Advocate General, except to the extent that his or her opinion is endorsed by the court.
But I mean, the main point is in Farrell and Witty itself, that the stress which is laid by the court on the task delegated. That's really where I get the strength to this point. common laws unless I can assist you further. Those are my submissions.
Thank you very much indeed. Yes.
My Lord, it's perhaps worth noting briefly in opening that there were three issues before the learned judge below. Second and third issue are about direct effect and emanation of the state. The first issue was the question of whether or not the national statute can be read down, and that was that case which my learned friend Mr Mercer has already referred your lordships to, Pilling, which has now been in the Supreme Court. Just to note, it is in that supplementary authorities bundle, if someone wants to look at it, and the Supreme Court has now
They endorse what Mr Justice Soole decided.
endorsed what Mr Justice Soole decided on issue 1. And so now we ask this court to endorse what he decided on issues 2 and 3 as well. I come first to the scope of the liability and my learned friend's points on direct effect. I have noted in my skeleton argument that the MIB has abandoned its protestations below, that it is not an emanation of the state. It now says it's an emanation, but not for this purpose. It has also acknowledged, in paragraph 41 of my learned friend's skeleton argument, that the decision of Farrell and Witty number 2 must be distinguished from the facts of this case for the present case that he brings to succeed on appeal. I note further that it is common ground between the parties that the special powers in the case of the Irish MIB, as identified by the CJEU, namely compulsory membership, is admitted to be the same as the position in the UK, and that's at paragraph 39 of my learned friend's skeleton argument. So it's with this in mind that I want to start with Farrell and Witty number 2, because it's my principal submission, as it was below, that really it's all in Farrell and Witty number 2, and insofar as we say it cannot be distinguished in any relevant way, we say that this court need only apply Farrell and Witty number 2 for this appeal to fail. That's at tab 12 of the authorities bundle. My learned friend has already taken your lordships to it. The facts are well known. It was not in Ireland obligatory to insure people in unseated parts of vehicles. So, for instance, if you wish to transport all of your fruit pickers to your farm on the back of a lorry, you have to take out different insurance. It wouldn't be covered by your RTA insurer. Lords, if we look at the judgment, which in this report starts at page 1224, we see the legal context there at 1224 3E to H, and the court is there dealing with what are now three articles of the current directive. They were then 2. First, it's dealing with Article 3.1, which is now Article 3 of the directive that we have in the bundle, paragraphs 1 and 2. Each member state shall take appropriate measures to ensure the civil liability in respect of the use of vehicles normally based in its territory is covered by insurance. The extent of the liability covered and the terms and conditions of the cover shall be determined on the basis of those measures. And then it also deals with Article 1.1 and Article 1.4. Article 1.1 is what is now Article 12.1. The insurance referred to in Article 3.1 for the first directive shall cover compulsorily both damage to property and personal injuries. That is the bit that was found expressly to be directly effective in Farrell number 1. And then the CJEU said, but we haven't got enough facts to decide whether it applies to this particular case, and sent it back, and the Irish court sent it back on a second reference for Farrell and Witty number 2, and this time asked quite specifically, here are all facts, is it covered? The third article is Article 1.4 of the second directive. Each member state shall set up or authorise a body with the task of providing compensation. My Lords, that is now Article 10 of the current directive. And my learned friend relies upon the fact that the Court of Justice has said that these obligations in what is now Article 3 and what is now Article 10 are coextensive because he identifies a limitation in relation to Article 3.1. I rely on the fact that they are coextensive to make the submission that we see from Farrell and Witty number 2 itself that the CJEU has considered these articles, when read together, to be liable to give direct effect to the victim, because, very simply, that's the outcome of Farrell and Witty number 2. And all of these articles, as we'll see, are interdependent. Article 1.1 already held directly effective in Farrell number 1 with its express cross-reference to Article 3.1. It incorporates Article 3.1.
Did you say that's the equivalent of Article 12 in the present directive?
I believe so, my Lord.
Isn't it just a tail piece of Article 3 of the
I
present
may have slipped there, my Lord. There is a table at the back of the current directive which gives all the cross-references.
I think my Lord is right. It is the tailpiece of Article 3.
I'm
It's
sure
now
my,
all in Article 3.
I'm sure my Lord is right.
Nothing turns on it. I'm just a bit
nothing
puzzled
turns.
about
That's
going
right.
to Article 12.
It's just, I don't know why I noted Article 12. I guess that is with the passenger. Well, yes, yes. I'm so sorry. But your Lordship is of course correct. And that's the tailpiece of Article 3. So we have that bit of Article 1, tailpiece of Article 3, which incorporates Article 3.1 and makes reference to it, already held directly effective in Farrell number 1, and then read together, as we shall see. If one looks further in the judgment at paragraphs 10 following, there we have the bit that's now, it's not in dispute, on all fours with the current case, as far as the facts and the law in this case are concerned. The Irish legislation, the 1961 Act, requiring insurers there to be members of the Irish MIB. And at 13, we have the facts. Mrs. Farrell was the victim of a traffic accident when she was a passenger in a van. At the time of the accident, Miss Farrell was seated on the floor in the rear of Mr. Witty's vehicle, the vehicle being neither designed nor constructed to carry passengers in the rear. It is therefore, I submit, already a case of the extension of the national insurance obligation in Ireland. It was not at the time necessary to insure passengers not seated in the rear of the vehicle, and the European Court, as we will see, had no difficulty in finding Ms. Farrell had a directly effective right in those circumstances. 15, the Irish MIB refused Ms. Farrell's request for compensation because liability for the personal injuries she had suffered was not a liability in respect of which insurance was required under Irish law. And so again, when my learned friend relies on the alleged difference between the obligation of the member states to set up a system and then what was required under national law, the court in Farrell had no difficulty with that whatsoever, and found, as we are about to see. If we turn on then to paragraphs 32 and 33,
Well, you would say, if we transpose paragraph 15 into the present case, there's no material difference. Mr. Lewis was injured MIB is saying that there's no liability for the personal injuries he suffered because it wasn't a liability for which insurance was required under English law.
My lord, yes. It's a straightforward point. I don't need to belabor it. In fact, I've slightly got ahead of myself and said, look at 32. It's at 29 that the court...
29.
At 29, the court then draws that conclusion, in effect, and says the answer is that Article 288, which is that should read TFEU, which is the article that deals with directives in the treaty, must be interpreted as meaning it does not in itself preclude the possibility that provisions of a directive capable of having direct effect may be relied upon against a body that doesn't display all of the characteristics listed in Foster's case. That's the conclusion on the first part of that case.
Accepting what one finds in much more detail in the Advocate General's opinion.
Yes, that's right. And then we come on, my lord, in Farrell, to the second and third question, and here we are, of course, also dealing with the question of emanation of the state and the question of the task. At 30, the court discusses in the final paragraph whether such provisions may be, in the final sentence, whether such provisions may be relied upon against an organisation on which a member state has conferred the task that is the subject of Article 1.4 of the second directive. So the subject of Article 10. And, my lords, I do make, again, a simple point. The directive speaks of a body. It doesn't speak of bodies, and it speaks of one task. And we have already seen, not least in the case law that my learned friend has taken your lordships to, that the obligation, the task we are talking about is the obligation to reimburse the victims of accidents caused by uninsured drivers. And it is really, in my humble submission, irrelevant whether you look at Article 10 or at Article 3. The task and the obligation and the member states' responsibility are coextensive. They are the same. It's not that one is simply looking at an obligation on individuals under national law to insure, and then somehow a separate obligation on the member state to put in place a system, and then near the twain shall meet. And that is what my learned friend very skillfully attempts to do. He attempts to say, oh look, over here we have something that happens between the member state and the EU, and that's putting in place a system. And then we have something that happens between the member state and the victims, effectively, which is to say that drivers have to be insured. But then he says there is no relevant connection between the two. Clearly, my lords, the whole point of what the Court of Justice is finding in Farrell and Witty is that there is that connection. And we know that at paragraph 32, the court says, in accordance with its settled case law, where a person is able to rely on a directive not against an individual but against the state, he may do so regardless of the capacity in which the latter is acting, whether as an employer or as a public authority. In either case, it's necessary to prevent the state from taking advantage of its own failure to comply with EU law. And this now goes to the question of the claim against the MIB in its capacity as an emanation of the state. And my learned friend makes the point, well, we shouldn't be made the primary compensator. But the fact of the matter is, however, my lords, we are not claiming against the MIB because the directive somehow correctly interpreted makes it the primary compensator. We're claiming against the MIB because it is, for this relevant purpose, an emanation of the state. We are claiming against them, if they are an emanation of the state, as the state. And it is on the basis of those considerations at 33 that the court has held that provisions of a directive that are unconditional and sufficiently precise may be relied upon by individuals not only against the member state and its authorities, but also against these other bodies as identified in Foster. And such organisations or bodies can be distinguished from individuals, such as the individual we see in Smith and Mead, which was just an insurance company. And it must be treated as comparable to the state, either because they're legal persons governed by public law, or because they're subject to the authority and control of the public body, or because they perform a task in the public interest and have been given for that purpose such special powers. And there is nothing between the parties on the fact that there are special powers in the sense that the insurers are obliged to be members of the MIB.
So, I mean, in a sense, your case is very straightforward and shortly put, isn't it? You say these provisions of this directive, or equivalent provisions in the earlier directive, which are materially identical, have been held by the European Court to have direct effect against the member state. Point one. Point two, the MIB of Ireland has been held by the European Court to be an emanation of Ireland, for which, against which, therefore, those provisions of the directive have direct effect, and there is no material difference so far as the English MIB is concerned.
Well, absolutely. That's why.
All the ingenious arguments about the different discretion, the discretion that's given in relation to what you do to comply with your obligation in Article 3 don't actually amount to, well, they're not open to Mr Mercer in the light of the decision of the European Court.
My lord, yes. It may well be, in other circumstances, in other directives on other facts, something will not have been delegated appropriately.
Well, it's interesting, isn't it, that all the cases that you referred us to are all under a completely different directive.
That's right, my lord. Exactly. They were under the directive, the Frankovich directive. And one of the interesting things, although I don't want to rest my entire case on it, is that Article 5 of the Frankovich directive talks about organisations plural. That the state is to put in place organisations in order to accommodate the various duties for different kinds of employees. That's not what this directive says, and indeed my learned friend conceded at the beginning, almost in opening, that on the face of it, Article 10 of this directive speaks of only one body. Of course, he then expanded on that. But it is interesting, again, to note in passing, yes, that was Frankovich, and as it happens, it was in relation to a differently worded provision as to the number of bodies that might or might not be required. It's also worth noting, and I'll come back to it after lunch, if your lordships find it of assistance, but it's also worth noting that in the line of Frankovich case law, when we end up with Gareveran and the Swedish state, things have rather moved on from Frankovich and Wagner-Miret to shall we say, more fulsome recognition by the Court of Justice of the European Union that where somebody has designated the body, in Gareveran it was the Swedish state having designated itself, then that is full implementation. And my submission, again, is very simple. It's not, in my respectful submission, it's not seriously arguable to say that the UK has not identified the MIB as the relevant body through which it has implemented its obligations under the directive.
But it has only done so in qualified terms, that is to say, limiting it to the RTA insurance requirement, and the special powers are equally qualified.
It hasn't qualified them expressly.
No. But that is the limit of the delegation and of the special powers.
What the UK has done is it's identified a body, the MIB, and it has, although, as my learned friend says, we can't find a communication between the UK and the EU, it has represented by conduct that it has implemented the directive, and it has implemented the directive by devolving the responsibility for the obligation on the MIB. With respect, I submit that delegation is without reservation because the obligation has been devolved upon the MIB. And since the obligation is a creature of EU law, and it is without limit, and we know that it includes use on private land, the UK has, de facto, delegated the entirety of the obligation. And it certainly has done so when viewed through the lens of the Court of Justice and European Union law, which is what matters. The fact that under national law, the RTA has certain exceptions which we now know to be unlawful under EU law, cannot benefit the state no more than different emanations of the state, such as the Secretary of State and the MIB, pointing at each other and saying, it's not my responsibility, it's his or its. The victim is entitled, by reason of the direct effect of these provisions, the purpose of which is the protection of the victims of uninsured drivers, regardless of where on the territory of any member state the accident has occurred. It is the entitlement of those victims to rely directly on the obligation against the state or the emanation of the state. And it is no more, it lies no more in the mouth of the MIB as an emanation of the state to say, yes, but these particular responsibilities have not been devolved under national law yet, than it would lie in the mouth of the Secretary of State. We're entitled to go against the MIB because it is the body, it is the correct emanation. And I rely squarely on Farrell and Witty, and an interesting reference in the Advocate General's opinion on that very point, I say, really puts the matter to bed. And that is, if we turn back to page 1212, within the report,
Paragraph 126.
to paragraph 126 in the opinion of Advocate General Eleanor Sharpson. This is, as the European Commission correctly points out, an unusual case, inasmuch as the Irish MIB's raison d'etre includes precisely dealing with claims brought by victims of uninsured drivers. It is in that specific context that the issue arises as to whether it is also liable to meet this particular claim, notwithstanding that Ireland had failed at the material time to transpose all its EU law obligations correctly into national law, and had not, brackets, yet, close brackets, assigned responsibility for meeting that particular liability to the Irish MIB. Is there reference to the fact that that's different from Marshall? And then at E, here the directly effective right that Ms. Farrell seeks to assert, compensation for injuries received as a passenger, under Article 1, is precisely the type of right for which Ireland had already conferred residual liability, where the driver is unidentified or uninsured, upon the Irish MIB. And if again I did the same exercise that my Lord Justice Flaux conducted earlier with the judgment, if I replace all of the relevant items with the facts of our case, it is exactly the same. The UK has failed at the material time to transpose all its EU law obligations correctly into national law, and has not yet assigned responsibility for meeting that particular liability to the MIB.
That's as a matter of national law, you say,
That's right.
albeit from the perspective of the EU and the directive. There has been a full delegation of the Article 10 responsibility.
Clearly it has.
That's what you say.
That must follow from this and from the conclusion of the court, which followed the Advocate General.
Yes, I must say I'm conceptually finding it slightly hard to get my head around. I mean, on the face of it, you think it's a matter for national law to decide what body it's going to set up, and it's a matter for interpretation of the agreement which it reaches with the body in question. And if you just look at the domestic agreement, of course it does not cover the type of case that we're concerned with.
Yes.
Yet here we have the Advocate General and then the court saying, well, it's the same type of obligation, and somehow that's sufficient to turn it into a designation for the purposes of Article 10. Now, what actually is the compelling force that achieves that result? I mean, is it a sort of supervening principle of EU law you have to superadd to the domestic contract, or what?
The supervening principle, I submit, is the teleological purposive approach that the CJU takes to interpreting EU law, which rests upon the purpose of the directive, which, as we know, is the general objective
well,
of victim protection.
I
pursued by
understand all that, but
legislation.
how does that actually lead to the conclusion that the MIB is here the designated body as a matter of domestic law for the purposes of Article 10?
Well, what the CJU does, for instance, in paragraph 42 of its judgment when it comes to its conclusions, is that it says that a direct effect may be relied upon against a private law body on which a member state has conferred a task in the public interest. And it characterises that task as being the indemnification, if that's the word,
Yes.
of uninsured drivers, accidents, victims.
So EU law is saying to the extent that the relevant task goes beyond the small print, so to speak, of the domestic agreement, it has to be treated as falling within it. I'm still
It does.
slightly struggling as to how one formulates this.
It does, and when it says that, because it says that is inherent in the obligation imposed on the member states by Article 1.4, now Article 1.10. The body possesses for that purpose special powers, such as the power to oblige insurers to be members of it and to fund it. And the court in Farrell and Witty has identified that as a sufficient implementation to bring that within the obligations of the MIB.
Certainly seems to be what they've done. I'm just trying to understand how they did it. Would that be a good moment to break off? Thank you very much. Should we continue at 2 o'clock?
All right.